Board meeting is now in session today. Let's stand for the moment of silence, followed by the Pledge of Allegiance. Okay, let us stand for the pledge. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Welcome, everybody, our visitors and our district staff and all of our board members. Welcome to our meeting. The first thing on our agenda is public comments, and just a reminder about public comments. Comments or requests should be brief and to the point as possible and shall not exceed 3 minutes and not mention specific names of students or personnel. Public comments will be aired live, but the board typically will not respond to individual comments. Our first person this evening is Mr. Winchester.
Good afternoon.
Good evening.
Can you hear me?
Yes.
Good afternoon, Mr. Chair, Superintendent, board members and guests. Seems like every week, myself and others come before you pretty much talking about the same thing. The dichotomy that exists between black students and white students in this system. Black staff members and white staff members in this system. And every week, it seems like something else comes up. This week, on the agenda for executive session, and it's not public record who it is, but one can deduce that this is in reference to the removal of the principal of Washington. Now, if that is the case, how is it that this individual is allowed to have a hearing when the principal of Carver's Bay was disallowed the same process? Other than the fact that one is black and one is white, what is the reasonable explanation that happened? And I think it's a problem that our superintendent has the sole power to decide who does and who does not get a grievance hearing. Because in many cases, that grievance is going to be in reference to something that he did. So how does it make sense that the person that is the head of the snake, that this is all going to fall in the lap of, get the choice of whether or not an individual gets to speak to their supervisor about what they have done? Just doesn't make sense. I feel like in this situation, we need to really take a step back and think about how we handle situations in this district, how we make it fair across the board. How do we handle a situation with one population of individuals one way and handle it a different way several months later when there's a different population of individuals, one black, one white? I just don't understand how that happens. And I know a lot of times we all sit up here and we say there's no difference in the way individuals are treated, but it's right there plain in front of us. One individual, black man, principal of Carver's Bay High School, threatened to be removed from his position, asked for a grievance hearing, was denied by the superintendent. One white individual, his position, asked for a grievance hearing, was allowed that process. Why is that? We need to look. There's been some serious things done here, and there needs to be serious consequences for everybody. Well, let me not say everybody, because we're not going after the children. The children are off limits. What they did, they did. But the adults that allowed that to happen and then covered it up later need to be held accountable for everything that happened. Thank you for your time.
Thank you, Mr. Winchester. Our next person is Mr. Gibson.
Good evening.
Good evening.
I want to first commend you, school board, for looking into the situation about what happened at Waccamaw High School. You saw the pictures. Those were just some of the pictures of what happened at Lackawanna High. And like I said, some people in Uvalde, Texas, cannot speak to their child because they were murdered because a door was left open. This is not a joke, people. It is not a joke. And I see on your agenda where you have an administrative reassignment and a grievance in an executive session. If the principal was moved to another school, I want you to think about this. And it was a problem with my child. And my child said, Daddy, I didn't do it. And the principal said, yes, you do. Who are you going to believe? His credibility is shot. His integrity is at question because he lied not only to you, he lied to the media, he lied to us, he made a mockery of this board. And for it to go unnoticed it's appalling. If he goes to any school, any person in Georgetown County that is watching this, if this man has a problem with your child, question it, because he's a liar. And you proved that he was a liar because you saw fit to relieve him of his duties because he did something wrong. He did something real wrong. Somebody could have died. When you drag race, you lose your license. Nothing happened. Videos out there probably went viral. What does it make Georgetown County School District look like? To demote a man or move a man and pay him the same money for a year that he would have gotten at his other job, that's just saying if I mess up, go to another job. That's telling the children of Georgetown County, if you make a mistake, lie about it. Cover it up. I got 43 seconds left. I'm looking to cover it up, and we got your back. That's not the way we do things in Georgetown County School District. And you guys made a great decision to relieve him of his duties, but make a better decision and hold him accountable for what happened at that school. Because you know what? We look around in Uvalde, we look in Florida, the same thing can happen in Georgetown if we don't take security important. Thank you.
Thank you. Our next speaker is Mr. Butts. It's just three, right? Okay.
May I approach, please?
Yes.
Take one past that, please.
Thank you, sir.
Good evening, and thank you for your time, Mr. Chairman, Superintendent, board members, and all the other administrators within the Georgetown County School District. I come to you this afternoon to talk a little bit about not what's fair and impartial, but what's just right and wrong. In my personal opinion, right and wrong has very little gray in between it. Either you're wrong, either you're right. Either you do the right thing, or either you do the wrong thing. And specifically, let's talk about this senior administrator prank at Waccamaw High School. Not just the seniors, but we had contribution from an administrative individual at the school to be a part of this prank, as they would say. I don't think it was a prank. It was actually breaking and entering. It was actually criminal trespass. It was actually vandalism. It was actually obstruction of justice. It was actually contributing to the delinquency of a minor. It was actually false official statements. It was actually child neglect. It was actually malicious destruction of property. I don't think you can put any of those crimes that I just stated just now and put prank in front of it or to the rear of it. There's so many things that could have gone wrong in that situation. So many things that could have gone wrong with individuals doing that situation. So many things that could have gone wrong to the property because of this incident. And if we don't take a clear look and purge our mental storehouse to figure out that this is not just a prank. Grown people that are entrusted to protect our children failed. And not failed just at one level, they failed at many levels, from the top on down to the bottom. Who are we going to hold accountable? As Mr. Gibson stated, the kids, they're just kids, and they're going to do what they are allowed to do. Allowed to do. They were allowed to enter the building. They were allowed to put oil in the toilet. They were allowed to drag race on the track. They were allowed to keep a door open for other things to happen at that school. Not them. They were allowed. We as adults, we got to do better, because I know we know better. And it's never the wrong time to do the right thing. You all, I ask you again, look within yourselves and don't gloss over this. Interpret it and digest and see that this is more than just a senior prank. This was a senior administrative-led prank that could have gone wrong in so many different ways. Thank you for your time and attention.
Thank you, Mr. Butts. Moving on with our agenda. The first thing on the agenda is approval of our minutes from our last meeting. Is there a motion for approval?
So moved.
It's been moved, and it's been second. All in favor, please say aye.
Aye.
The minutes have been approved. Next is the adoption of the agenda. You see the agenda is a motion to adopt the agenda.
So moved.
It's been moved.
Second.
Second. All in favor for the adoption of the agenda, please say aye.
Aye.
The agenda has been adopted. The first thing on our agenda is the personnel list, which you have all received. The administration recommends the approval of the personnel list as presented.
So moved.
It's been moved.
Second.
It's been second. Are there any questions? Hearing none, I ask for the question. All in favor, please say aye.
Aye.
Opposed? The personnel list has been approved. The next thing on the agenda, which I'll call Dr. Giles, Policy JICDAE-E, Student Code of Conduct. The administration recommends first and final approval of Policy JICDAE-E, Student Code of Conduct as presented. Dr. Giles.
All right. Good afternoon, Chairman Gaskins, members of the board, Superintendent Price, District Administration, as well as our Georgetown County School District family. The Code of Conduct has been presented. I have at this time, however, an amended version that reflects and addresses the request that you've made. So just as a reminder, our Code of Conduct reflects a template that involves offenses, suggested interventions, consequences, as well as law enforcement involvement indicator. So as we dive a little deeper, we're going to look at the Code of Conduct cover sheet first. Requests that were made or suggestions that you made involve repeated offenses should go up in consequences, as well as making it clear that 3 level 1 offenses do not have to be the same. So after we've reviewed it, we wanted to reiterate that will and shall do not allow for administrative discretion within the policy. However, we've included the word should, so it reflects the administration should reclassify behavior misconduct, level 1, as disruptive conduct, level 2, if the student has an accumulation of any 3 or more documented offenses. So The NE3 allows for, it can be an accumulation of various offenses. It does not have to be the same offense. So we hoping that we've captured your request. The second request that I will address is in level 1, behavioral misconduct. In this, you'll see the strike through. That represents us moving cheating and forgery to level 2 instead of level 1. So as requested, that'll be reflected in level 2. I also want to point out that use of forged notes is in level 1. And this gives us more alignment with state guidelines. The state regulation specifically says a local school board in its discretion may authorize more stringent standards and consequences than those contained in this regulation. Also, it was asked about interventions. Do we have too many options for interventions, or should we limit options? And it was also asked, should interventions accompany consequences but not substitute them? So it does appear that there are many interventions. However, it's important to note that some of these interventions are specific to the consequence, so it does make the list look longer. However, they're specific to the consequence. In addition, it does give schools the flexibility and options to assign an intervention that they can accommodate within their school. We've also added the statement, interventions should be assigned along with appropriate consequences, not in lieu of. Our next changes are in level 2, disruptive misconduct. Again, as requested, cheating and forgery have been moved to level 2. There was emphasis on bullying. We've added a definition that we feel is a better working definition for bullying. Our hope or our intent here is that it will help with the consistency of determination of whether a situation is harassment, intimidation, or bullying. Another point made in level 2 was profanity towards a teacher. In your request that there should be a clear and consistent consequence for using profanity towards a teacher. So if you note, there is profanity and inappropriate language, abusive or vulgar language, swearing, cursing, foul speech, or derogatory language that shows disrespect towards an adult. So it's not just a teacher, but an adult within the school setting. And there are level 2 consequences for this. Also within level 2, it was noted for vandalism. The dollar amount has been removed, and it's important to note that the dollar amount is only relevant when determining when there are criminal charges. If there are criminal charges, that makes it a level 3 offense. The other point about vandalism was, should there be a minimum number of days of suspension? So we've removed the option of ISS and detention, and discretion still is allowed for the number of suspension days.
Ma'am, I got a comment
Yes,
on vandalism of any dollar amount is a class 1 misdemeanor in South Carolina. So it is a criminal offense. If I spray painted this board up here, I just committed a class 1 vandalism because it's graffiti. So it is a criminal offense, punishable by fine and imprisonment. I think we need to remind all our SROs, administrators, that it is a criminal offense in South Carolina. Specifically, the South Carolina Code of Law addresses schools. So if you look up the law, schools was important enough for the General Assembly to put in that law. So we need to take graffiti and vandalism as a criminal offense.
We'll note that, and it's reflected that law enforcement is notified, and they'll make that determination. If we would like to move it to level 3, that's where the criminal activity.
Yeah, I just want to be consistent with state law, Alan.
Yeah, and good evening, everybody. I think what this is really trying to address, Mr. Cox, is in the cases where a decision is made not to prosecute, In that case, if it's not a criminal offense, if there's no prosecution for it, so there would be an alternative punishment for it. So I think, kind of like we talked about last time, between assault and battery and fighting, and larceny and stealing, so that you've got something there that you can address instances where law enforcement's made a decision not to prosecute.
Thank you.
Thank you. And so in level 3, it was noted that arson has a asterisk beside recommendation for expulsion. So to make it clear as requested, we've added and it's highlighted that it's mandatory, that the asterisk there means mandatory. So even though it's indicated later within the template, we put it within each cell so that it's noted that it's mandatory.
Dr. Giles, may I ask a question? Where does vaping fall into the code of conduct? Because I know vaping is on the uprise in our schools.
Could you repeat that? I'm sorry, I didn't hear you.
Students who vape at school, where does that fall into this? Because I know that's on the uprise.
It's part of the board policy that deals with tobacco products and things like that.
Okay.
So we went back and rewrote that a few years ago and specifically included vapes, e-cigarettes, and the paraphernalia associated with it.
So if a student's caught vaping at school, would that be a level 3 code of conduct?
No, it's level 2.
Level 2?
Yes, sir.
Okay.
There. Within the 1 second to the last, possession of tobacco products, including vape and electronic cigarettes. And so one additional note, or 2 additional notes. It was asked about fighting, and it was noted that we should include a definition possibly that includes self-defense. After talking with Ms. Thompson, Mr. Walters, and looking at all the perspectives, we pretty much agreed that it is situational. Adding a definition as such would be in a self-defense law, which doesn't exist in South Carolina. Mr. Walters may want to add more to that due to his background, but again, that's situational.
Yeah, with this, and Ms. Thompson and I had a lengthy discussion about it, and we did some research. As you all sure know, I was a magistrate municipal judge for 17 years, and so we would have to actually charge juries with self-defense. In South Carolina, there's a stand your ground law, and that is what people commonly think of as self-defense, but that's only in cases where somebody feels that is imminent with death or great bodily injury. And so in fact, I went and found the old charge book that we used to read to juries about self-defense. And the first element of that would be is that the defendant must be without fault in bringing on the difficulty. So that is the issue that administrators have to make a determination about if they're looking at should there be disciplinary action against one or more students or just the one who perhaps was an instigator. Another one is about the use of contemptuous language. Self-defense is not available to a person who uses language which is so contemptuous that a reasonable person would expect it to bring on a physical encounter. So, of course, we don't expect our administrators to be lawyers and judges. Certainly we provide them with guidance with it. Mostly it comes back to really common sense, is that was the response of the second party appropriate, was it actually defense, or did they take it beyond defense and become an aggressor? And I think that's really the crux of it. That's where your SRO is going to be important, because they're going to have to be the one to make that determination in regard to possibly filing any charges.
Thank you.
I got one comment, Mr. Chairman, on that. We discussed in one of our committee meetings, and the last time we went over this, about the self-defense. And one of the things you guys had told us was when there's an incident between two people, it's immediate that both get suspended. And my request was, before their suspension, could there be an investigation? You know, just don't, if it happens at 3 o'clock on a Monday, don't suspend both kids on Tuesday, Wednesday, and Thursday until an investigation is done. So we could determine, was it self-defense? Because there have been instances in Georgetown County where kids are defending themselves from an attack, but yet they get suspended. So is there something we can do to improve that investigation to figure out, like you said, common sense, was the other person at fault?
And Mr. Cox, this is where we have to work with our administrators in teaching them how to actually conduct that investigation. First and foremost, and I hate to keep repeating this, you got to give deference to the SRO, because we don't arrest anybody. We don't prosecute anybody. That's a law enforcement decision to do that. We're not actually the victims of a crime. All crimes are against the state of South Carolina. You can have someone who is a victim from somebody getting hit, but as far as prosecuting, they have the sole authority to make that decision. So that's the first thing that's got to be determined. And we're meeting with our SROs for training on August 1st, and this is part of what we're going to go over with them as well, is that they got to collaborate and not only do it together, but also do it quickly. Because what you don't want to do is, in your example of taking a day or two to investigate, if both of those students are into school, and something else happens between those two students, now you've not only put them at risk, but the district's at greater liability for leaving them in place where that could happen. So we do need to investigate, we need to be thorough with it, but we also need to be prompt with it. But I think, to your point, there's a balance that they can take the time before they make that decision, whether it's 30 minutes, an hour into the school day, before they do that. But they do need to ensure that those students are not going to be an issue with one another while that investigation takes place.
Yeah, normally that investigation takes 2 or 3 hours, or does it take 2 or 3 days while both kids are at home?
And it depends. If it's 2 kids and it happened in a hallway and we've got video and we've got witnesses, it can be fairly quick. If it's 6 kids and they're in a restroom and there were no adults present, it's more complicated.
Gotcha. Thank you.
Thank you.
And just out of curiosity, let's say there's a fight that happens and someone started the fight. You're just standing there, someone comes and sucker punch you, then you swing back, and it's a fight that's started. Tell me, what's the procedure now as far as handling that? Would both kids be suspended under those circumstances, or?
Within fights, now I will tell you as an administrator, we ask our kids and we try to teach our kids, their response is just as big as their actions. So we want to teach our students to be responsible with their actions. So if there is that opportunity to walk away, seek an adult, try to do the right thing. And the last point that was made was asking about a cool-down period. I will share with you that we met recently last week with our administrators, and one of the things that we stressed was consequences need to be assigned, first and foremost. Secondly, that consequence shouldn't be, we've talked to you, now go back, right back into that class. We need a cool down period, as you all have stressed, or there needs to be a period of separation between whoever it involves, whether it's an adult staff member or another student, but there needs to be a point of separation at that point. So I present to you the changes and the reflections that you've made in the Code of Conduct just under level 1, 2, and 3 for your consideration. At our next meeting, it's my goal to bring before you, just for the sake of brevity, our school bus codes, to review those as level 1, 2, and 3, along with our discipline progressions for input.
Thank you very much.
Thank you. Any questions?
So we have a motion in front of us. The administration recommends first and final approval of this policy, JICDA-E, Student Code of Conduct as presented. Is there a motion? It's been moved. And second, is there any questions? I call the question. All in favor, please say aye.
Aye.
All opposed? The motion is carried. Dr. Giles, you're up again for Administrative Rule IKF-R, Graduation Requirements. The administration. And Lindsay and Thompson, sorry about
I was just going to field any questions and then see if I could help out, give her a little bit of a break here.
All right. The administration recommends first and final reading approval for the Administrative Rule IKF-R, Graduation Requirements as presented. That should be pretty simple.
So moved.
It's been moved. Second. Any questions? All in favor, please say aye.
Aye.
All opposed, nay. The motion is carried. Thank you. And here we go again with policy GCC, employee leave and absences. The administration recommends the administration recommends first reading approval of policy GCCC, employee leave and absences as presented. Is there a motion?
So moved.
It's been moved. Is there a second?
Second.
Is there a second? Is there any questions you would like to ask? Hearing none? All in favor, please say aye.
Aye.
All opposed? Hearing none, the motion has passed.
Thank you.
Dr. Barno, out-of-district transfer request. The administration recommends approval of Georgetown County residents' request for a release from Georgetown County School District for the 2023-2024 school year. Is there a motion?
So moved.
It's been moved.
Second.
Second. Is there any questions? Hearing none, I'll call for the question. All in favor, please say aye.
Aye.
All opposed, say nay. The motion is carried. Now we move into information items. The first thing on the agenda is Mr. Price, Athletic Capital Project additions.
Excuse me.
All right. Good evening, Mr. Chair and ladies and gentlemen of the board. At the board's request, I am bringing this presentation back for discussion with regard to two athletic topics that you have inquired about. Before moving to those two topics, I would like to review the 5-year operations plan that Mr. Davis presented a couple of weeks ago. The 5-year plan was built based on the 10-year facility study completed by MB last year. The plan included needs and wishes of varying costs. The more urgent needs will appear earlier in the 5-year plan, and the Year 1 plan includes LED lighting upgrades, interior painting, replacing exterior doors at 2 schools, a storage building at 1, and upgrading sound systems at 3 schools. The Year 2 plan includes upgrading and replacing door hardware in all facilities, interior painting, partial roof replacement at 1 school, and flooring upgrades in 5 schools. The Year 3 plan includes more door hardware upgrades, interior painting, partial HVAC replacement at 1 school, and parking lot paving at the 4 high schools. The Year 4 plan includes more interior painting, gym bleacher replacements at 2 middle schools, and parking lot paving at all elementary and middle schools. And the remaining item for Year 5 is a full HVAC replacement at 1 high school. The 5-year plan was approved as presented last month. Moving forward, there were 2 additional athletic requests that were mentioned, and before the 5-year plan were these other 2 topics. These did appear in the 10-year facility plan, but did not make it into the more urgent 5-year plan for immediate needs. The 2 items were an upgraded athletic entrance at Carvers Bay High School and a softball field house at Waccamaw High School. Mr. Davis worked with contractors to establish an estimate for each project for your information, and you can see those estimates on this slide. Things to consider with the Carvers Bay High School entrance. Prior to the bond referendum, I believe this was reported on at our last board meeting by Mr. Sabire, that prior to the bond referendum projects, Carvers Bay had the most significant athletic entrance in the school district. Since the bond referendum projects, that's no longer the case. There has been an inquiry for upfitting the Carvers Bay High athletic entrance to be more in line with what is in place at other schools, and that estimated cost is just over $1 million. So there's 2 payment options if the board chose to move forward with this project. One would be to remove items on the 5-year operations plan and replace them with this project to accommodate the cost. The other option would be to approve a one-time transfer from the reserve fund into capital projects to cover the cost of this project. Just for comparison, we got photos of the entrances at the football stadiums or the athletic field stadiums. And here you see the new entrance to Andrews High, the entrance at Georgetown High, the entrance at Waccamaw High, and the entrance at Carvers Bay High. Moving forward, the other topic was a softball field house at Waccamaw High. Things to consider, that each high school has an athletic field house in its athletic facilities. Only Georgetown High has a field house dedicated specifically for softball. This was reportedly built and funded by boosters many years ago. Only Georgetown High and Waccamaw High have a field house specifically for baseball. These were also reportedly built and funded by private citizens or boosters many years ago. The softball teams at Andrews, Carvers Bay, and Waccamaw do not currently use the field house that is on their campus. The estimated cost for adding a softball field house at Waccamaw would be $700,000. And similarly, there are 2 payment options for this project. One would be to remove items on the 5-year plan and replace them with this project to accommodate the cost, or to approve a one-time transfer from the reserve fund into capital projects to cover the cost of the project. Here you see the athletic field house at Andrews High. It is in close proximity to the softball field. It is used in the summer and fall by football, varsity on one side and JV on the other. And then during the spring, baseball uses one side while the other remains vacant. It is available for softball to use, but they currently choose not to.
Why?
The stadium field house at Andrews High is located at the far side of the football field and would not be convenient for softball use. This is Carvers Bay Fieldhouse, and it's located at the entrance of the football stadium and is only used by the football team. Neither baseball nor softball use this facility in the spring due to convenience and location. The Waccamaw High Fieldhouse is located in the end zone of the football stadium or the athletic stadium near the entrance. It is used by football in summer and fall, and then by boys lacrosse and boys soccer in the spring. It was made available to softball in the past, but due to boys being on one side, it was not utilized. just a concern about making sure that boys and girls accessing the same facility and being a management challenge, I believe the decision was made at that point for the softball team not to take advantage of that. This is a picture of the baseball field house that was built by Boosters some years ago. That's located next to the baseball field. This is the field house on the campus of Georgetown High. It is used by football in the summer and fall and by soccer in the spring. This is a picture of the softball field house at Georgetown High, adjacent to the softball field. It is only used by the softball team. Mike Johnson Park, which is off campus, also has a locker room designated for the baseball team, and that was built by Boosters many years ago. So that's a kind of a quick overview of the two projects that have been inquired about, one being the athletic entrance at Carvers Bay High, the other being about a potential softball field house at Waccamaw High. And I'll do my best to answer any questions you may have at this time.
Well, first I'd like to say thank you to Mr. Davis, Ms. Johnson, and yourself, Mr. Price, for getting creative and figuring out how we can make all of Georgetown County School Districts look the same. I do appreciate that very much, and I certainly look forward to working with the board and getting a recommendation to do that one-time transfer and to get this going, because, like I said, the only difference between 4 high school and 1 is that interest there, and I just thought it would be important for us to have consistency as far as the appearance of our schools. So thank you very much.
Yes, sir.
At this point, my memory's not very good because I know we've covered this, I think, in one of our previous meetings. How much do we anticipate having in our reserve fund at the end of this school year? Ms. Johnson?
Ms. Johnson is here. I believe at last count it was approximately 22.5.
I believe that's what I estimated. I think it's 20.6 right now, and I estimated about a $2.5 million increase.
And what is the level that we should have in a reserve fund?
There is no real rule or law. The state monitors to make sure that we keep I forgot the level, but a certain amount so that we don't go under fiscal watch. But
Are we above that amount? By how much?
I can get that.
Okay.
I'm sorry.
Thank you.
Yeah, I believe we don't, I don't know what that threshold is, that if you dip below that, then you get on
Right.
fiscal watch. But we are above that, and I believe that if these projects were funded for that, out of that account, then we would still be above that threshold.
Okay.
The thing to remember with the reserve fund is that all of the different sources that go into our operating budget do not all come at the beginning of the year.
Right.
They come in spurts. And so in order for us to make sure that we can pay all of our bills, issue all of our paychecks and all of that, we use that reserve fund to dip into when we're waiting on funds from state, federal, or local commodities to come in. And so that's the key ingredient for, or the key purpose for that reserve fund is to continue to be operational so that we don't have to go take out loans to pay bills and make payroll. So that's where the reserve fund is what it's for, and the other primary reason for it is to help with one-time cost or emergencies. Anything you'd like to add to that, Ms. Johnson?
No, that's correct.
Okay. Are there any other questions?
I don't think there are any things on our 5-year plan that we could change as we look at it. I think everything that was outlined looks like routine required maintenance. But I do think we have money this year that was left over to put back in our reserve that would cover these costs. And if we were okay before this year, I would assume that we are going to be okay with those expenditures. But I really think that would have to be a one-time expenditure. I don't think we could use the way that we are planning our maintenance.
Yes, ma'am, that's correct. The sum of these two projects together, based on the estimated quote that we've been given, would be less than the amount that we plan to add to our reserve fund budget after this year's books are closed out.
Yes, sir. Thank you.
And
Anything else?
I have a question or
Yes.
comment. I don't know which it is. So we're saying that at Andrews High, Carvers Bay High, and of course Waccamaw, they don't use the field house on the campus for the girls, which I understand that. Obviously, we're not going to put baseball team and softball team together in one place. So we build this at Waccamaw. So what happens next year when Andrews High says, well, hey, they got that, we want this?
So great
Carvers
question.
Bay High says, hey, they got that, we got that.
Great
Because
question.
we talk about, making everybody fair, and that would be fair.
That's a great question. And let me take it one piece at a time. With regards to Andrews High, they have their field house that is located between the softball and the baseball field. And during the spring, it's divided. So it's not one great big room. It is divided. So and baseball only uses one side. So softball could use the other side. You just need to monitor to make sure there's no crossing over
Right, so it's
between the male and
doable, but-
female athletes. So
Right.
that's there. At Carvers Bay High, they have an athletic field house that's not being used in the spring until spring football goes through their spring practice. But it's all the way up at the football field. And if you're familiar with their facilities, their softball and baseball fields are located past that. So I believe that they're not using it out of convenience and distance away from their field. So they take care of getting dressed either at an indoor locker room or on their own, and they come ready to practice or play.
Right. But that opinion could change next
That
year.
could change, right. At Georgetown, they have a softball field house, they have a baseball locker room. So those two spring sports are covered. At Waccamaw, you've got that field house that's available on the football field, but you've got lacrosse and soccer that are using it there. So there's an extra lacrosse team that the other schools are not fielding, so they're using it for locker room space. Baseball has theirs, softball doesn't. They could work it out to where everyone would get a turn,
Right.
but there would always be someone who's left out.
Right. I have no problem with obviously agreeing to build that at Waccamaw High. I'm just concerned about in the next couple of years when things change or somebody says, hey, we don't want to share or we can't because we're all together, and so.
And I don't believe Mr. Sabire is here this evening, but if that's an inquiry that the board would like to make for information before any decision is made, I would assume it would be roughly the same cost if you do a field house at one place versus a field house at another.
And of course, it may never happen, but,
Right. But I would assume it.
I mean, we like to be the same, and if this school has it, I want that at my school too.
Field house at, say, Carvers Bay High near the baseball, softball
Right.
fields, then the cost for that would be roughly the same as to add one at Waccamaw for
Right.
softball.
Hey, Ms. Kathy, that's in the back of my mind, but I don't take small bites.
Well, I understand that, and again, I'm looking to the future, but I'm still
And honestly,
looking.
it's necessary there.
Right,
so
because-
I understand the budget is in place, and we were asking for this right here.
Right.
I'm also in communication with my administrative at Carvers Bay to try to find our priorities.
Right.
And that's going to come out.
Oh, yeah.
And we're hoping that the budget and later on will allow for us to be able to obtain these things which are necessary for our kids.
Yeah.
So certainly, please know that I'm very concerned
Yeah, well,
about
that's,
what we need at Carvers Bay High School.
Oh, yeah.
Yes, ma'am.
Mr. Price,
Yeah, go ahead.
could you remind me how many of these field houses were built by private booster funds and how many came from the school district?
To my understanding, at Georgetown, the softball field house and the baseball locker room at Mike Johnson Park were built by boosters or private citizens. And at Waccamaw, the baseball field house was built by boosters or private citizens. The other field house facilities were constructed by the school district.
Okay, thank you.
Speaking of, looking at the 5-year plan, and I know you and I have talked about is the concern coming from Andrews High School about the safety at basketball games with the entrance. I think that's something that we need to look strongly at with the entrance there, because there's this concern how people are coming into the building. And I know the request is for a own separate entrance to the gymnasium. I would love for us to begin looking at that and exploring that, because I know that Carvers Bay High School, but I've never heard this concern at Carvers Bay High School. They have the same issue, because in order to come to a basketball game, they have to come, I think they come through the front door to a basketball game.
They come through the side door that comes in from the auxiliary gym
Right.
side.
Yeah.
And they come through, and they have a hallway there where they've got the metal detector set up, the screening for passes, the ticket, they take money for tickets. So it's different than the Georgetown and Waccamaw entrance into the basketball,
Right.
the basketball arena, or the gym, because of the reception area and how it's accessed.
Yes.
You come from the outside straight in at Georgetown High and Waccamaw, but it's different at Andrews and Carvers Bay.
And I know in the 10-year building, building plan, it was listed as a want, not a need.
Correct.
I request that your team look at that very seriously, and I know we probably, because I think in that plan, it was going to be like $2.5 million if you build a separate entrance. But we need a plan in place for security there when basketball season and volleyball season begins.
And I know that Dr. Giles, who oversees athletics for us, and Mr. Walters, who's over safety and risk management, they've actually gone out and met with Principal Mahone there to discuss that specifically. I don't know if there's anything that either of them would like to share at this point, but I know that's been a topic of discussion for planning efforts already.
Okay, great.
I would just say, I think, actually, we were probably over there the same day y'all may have been over there a little earlier.
Me and Ms. Johnson
And,
was out there a few weeks ago.
And so what we looked at is in the interim, until whatever solution may come down the road, is that how we can, we looked at various methods to possibly change how you get into Andrews. So, it used to come in the front door, use that hallway, kind of like we did when we had graduations. So that was an option. Either way, it takes more people. And so it takes more staff, not necessarily more law enforcement officers, but it does take more people just to monitor, because the way that school's laid out, you've got hallways. You got to have access to where the concession stand and the restrooms are, but make sure they're not going beyond that.
Thank you. Anything else for Mr. Price?
Yes.
Yes.
When we started this, this referendum a few years back before your time, and everybody had the entrance to the stadium, and that was one of the biggest requests from the Carvers Bay community that was on the wish list. So I think it's time that we try and find a way to get them up to par as well. So this has been out there for a long time.
Thank you.
I appreciate the research that has gone into it, and I'm definitely in favor of both requests. I also agree with Ms. Anderson about us being proactive. I don't think this is an either or, but I want us to be proactive in looking to the future, so that if and when requests come up in the future, we have a way to pay for it.
Thank you very much.
Thank you.
Next thing on the agenda, we bring back Ms. Thompson, Policy Exhibit GCBC-E, Extra Duty.
Did you read it all before? There wasn't any.
Good evening again, Chairman Gaskins, members of the board, Mr. Price. The first policy or exhibit that we have as an information item tonight is the extra duty exhibit. And you can see in here that this is where we have historically housed all of our supplement information for athletic supplements and other academic supplements, that sort of thing. And Mr. Jenkins is up here as well to field any questions, but this is kind of caused a problem in the past that we have this in board policy, because every time we need to make any kind of a tweak to any of the supplements, we have to bring it in front of the board for a vote. We have not been able to find any other districts that have this in a board policy manual. We're not sure how the decision originally came about to put this as a policy. So it doesn't necessarily fit in line with normal policy rules. So our request from administration will be that we remove this as an exhibit from the policy manual, and that we keep you abreast at meetings and that sort of thing when it's talking about budgets and we're talking about personnel planning, that we keep you abreast of what the supplements would be, but not necessarily have them in a policy. So, and I don't know if Mr. Jenkins has anything to add to that.
So to be fully transparent, we would treat this just like we do our teacher salaries and our administrative salaries. We would bring them to you on a yearly basis to let you know what they are, and they will be posted on our website. But there again, it just, as you know, we've been working hard on our academics and our athletic supplements, but before we can actually start to pay those, we would actually have to bring it to you for a vote and approval. And if there was any dissension and it was not approved, then we would have to go back and undo everything that we had worked really hard to accomplish.
Is there any questions? Thank you. Move on to the next one.
Okay.
Administrative Rule IJND-R, acceptable use.
Yes, sir, thank you. So it's my understanding that there were some of you that wanted to discuss a very specific provision of IJND-R, acceptable use policy, and that would be under the personal use of district research and communication resources, or excuse me, the paragraph above that, handheld communication device usage, which I think is on page, oh gosh, my pages aren't numbered, I apologize, 1, 2, 3, 4, I think it's 5, Ms. Kibler. Right there, yes, thank you. So the last line in that paragraph under handheld communication device usage states limited use of cell phones and or handheld devices in the classroom is permitted at the discretion of the classroom teacher. And I think there were some of you that wanted to have a little bit of discussion about that particular line. And I also wanted to let you know that in our student rights and responsibilities policy, we have very similar language there. That's policy JF. And in that one, it states that student cell phones must remain out of sight, turned off, and not activated unless approved by a teacher for educational uses. So essentially the same concept, just a little bit of different wording. But I don't know if you all have some different thoughts or ideas about where we might head for cell phones in the future. So.
Any questions for Ms. Thompson?
No questions.
Comments? Thank you very much. And next on our agenda is social media class action lawsuit with Ms. Thompson and Mr. Dave Duff, one of our district attorneys.
Yes, sir. Thank you so much. We do have Mr. Duff here. We also have an outside counsel attorney, Mr. Cutler, who will be he'll be presenting us a PowerPoint. We're having some kind of technical bumps here, so I think we're going to have Mr. Cutler on speakerphone. Is that correct?
I think we're going to see exactly how much delay there is.
We believe there's going to be up to a 20-second delay between what Mr. Cutler can hear and what he can see. So we're just trying to make sure that we make this run as smoothly as possible. So if y'all will just be a little bit patient with us here. And if you have any questions for Mr. Cutler, I can type those into the chat box. We'll make this work. But the idea here is to talk about a new class action lawsuit that's existing on social media litigation, very similar to what we joined with the Juul litigation for the vaping. Just obviously a very different defendant, but same kind of concept that we talked through. So Mr. Duff and Mr. Cutler here have all the information that they will be able to share about how that would look, about what the lawsuit's about, and what our involvement would look like. So I'm going to see where we go from here.
Is he?
Let's see. Mr. Cutler, can you hear us? Yes. Can you all hear Mr. Cutler? Just me? Okay, give us 1 second. Sorry, Mr. Cutler. No problem. Okay. Mr. Cutler, can you say something else for us to see if we can hear you?
1, 2, 3, test. Testing 1, 2, 3.
Any better, guys?
Not much.
Okay. I'm going to hold it up to the microphone over here, or actually I'm going to see if I can move it. This way. What about that?
Try now.
Is that any better?
Yes.
Okay. All right. I think we're set. And I am going to try to navigate through the PowerPoint as you begin speaking, Mr. Cutler.
Okay, thank you.
Okay. You might have to speak up.
Maybe I don't need the mic if I project loudly enough.
There's other mics that should pick up.
Once again, good evening, board members. I introduced myself before the meeting got started. Once again, my name is Dave Duff, and I'm with the Columbia School Law Firm of Duff, Freeman, Lyon, and we are one of the law firms that represents the district, works with the superintendent and Lindsay Ann when called upon. So I appreciate the opportunity.
I'm trying to figure this out.
I think I'm rebounding.
Yeah, you are. We'll just let you.
I appreciate the opportunity to take a few minutes to discuss with the board and with Mr. Price a topic that I think is very important and certainly timely, and that is the impact. Although social media obviously has its benefits, it also has some very serious negative impacts on our adolescents and youth, including students in the Georgetown County School District. I'm sure you're confused about lawyers and law firms. Mr. Mike Cutler is a partner in the law firm of Wagstaff and Cartmel, which is based in Kansas City, Missouri, and is the firm, probably the leading litigation firm in the Juul vaping litigation. Some of you may know that as a result of the settlement with Juul Labs, many districts, including several in South Carolina and including your district, received a gross monetary settlement. If I'm correct, I think that was roughly $150,000 that you could use to address the vaping problem in your schools. There is now a similar, in some ways similar, although again it's a different case, but there is similar litigation that has now been commenced in the same federal court in what's called the Northern District of California, which is the federal court in San Francisco, which is where the Juul litigation was initiated on behalf of 1,500 public school districts around the country, including several in South Carolina, including your district. So the social media litigation is initiated in the same federal court, a different federal judge, but it is a mass action, not exactly the same as a class action, but a many multiple school district plaintiff individual claims, but all are very similar and consolidated, again occurring in the federal court in San Francisco. And it addresses the negative impact of social media on our young folks. And if I'm not sure exactly what materials that might have been in your packets that I had forwarded some time ago to Lindsay Ann and to Mr. Price. I think it may have included a report from May by the U.S. Surgeon General, who pointed out the significant risk that social media, the some of the abuses related to social media and how they're impacting our young people. And some of those negative consequences, as you may know or have read about, are anxiety, increases in anxiety, in some cases depression, even sleeping and eating disorders, body image problems for particularly young females. And in the classroom, you know, it gets to the point with some of our children that they can't really function without looking at that smartphone. So in the classroom, it has the impact of can they concentrate long enough on what's being presented in the classroom? Can they focus? And can they be attentive long enough to receive instruction? So these are some of the impacts. And this this lawsuit is, although there are a lot of concerns about inappropriate and harmful content that's disseminated through social media platforms, this suit is focused not so much on content, where there are First Amendment and other liability immunities. It's focused more on certain features of social media platforms, such as, and you may have read about this, these targeted algorithms, and even such things as the like button, that are designed to maintain connection by our young folks with the social media platforms. So it is, in my opinion, it's actually a potentially more serious problem than the vaping problem that we dealt with previously. And many public school districts have acted to join the social media litigation that's occurring. Several in South Carolina have already indicated. I know that all of the districts in York County, including Fort Mill, Rock Hill, and the other two, have acted to join. I know that Lexington 1 and potentially Lexington 5 are likely going to join. In Beaufort, the same decision is on the table for that board to act upon. And you're not acting, it's not an action item this evening, right?
It's information.
It's an informational discussion. And you may have the opportunity to take action at a subsequent meeting, maybe your next meeting. So this is informational. So I've actually said probably too much, and I think you may have a hard copy of the PowerPoint. I'm going to ask Mr. Cutler, again with the firm of Wagstaff and Cartmel, which I did a lot of work in the Juul litigation to determine who I thought were the best litigation firms in these kinds of lawsuits. And I know that Wagstaff and Cartmel have had leadership positions in Juul, and again, they are in leadership positions in the social media litigation. And I mean, it's a practical matter. There are only 4 or 5 firms across the country that are really actively bringing and prosecuting the lawsuit. There are lots of firms that are recruiting school districts, but they're all the districts that join are being passed on to real handling of the case with one of these, 4 or 5 law firms that do a lot of this kind of litigation. And Wagstaff and Cartmel is one of those, and in my view is as good as any of the others, if not better. Wagstaff and Cartmel, just again going back to the Juul case, Juul Labs settled before there was an actual trial. The company that owns a substantial portion of Juul, which is Altria, refused to settle and went to trial in December of last year. and the Wagstaff and Cartmel firm handled the bellwether cases on behalf of the San Francisco School District, and eventually in the middle of the trial, Altria finally gave up and settled as well. So let me at this time turn it over to Mr. Cutler for the PowerPoint, and Mike, please, move through it as quickly as you can, hitting the high points, because we do have a hard copy and want to leave a little time for board members if they have questions. So I don't know whether we're going to get a delay here or not. Maybe we've got this
We'll see. We'll see what happens.
going. Okay.
All right. Well, I'm going to start talking now. Dave, thank you for that. And so with, I guess, the beginning of my speaking, I'll ask, was there a delay after Dave stopped there?
No, sir, we can hear you right on target.
All right. So I think we're all set. So thank you again, ladies and gentlemen of the board, Mr. Chairman. We really appreciate the opportunity to speak with you all. As Dave mentioned, I'm in Kansas City, Missouri. Next time we do one of these, I probably ought to make my way out there to coastal South Carolina. I've been out there a little bit. It's been years ago, though. So anyway, so do we have the presentation up?
Yes, we do.
Social media engagement PowerPoint. All right. So let's dive right in. We'll go to the second slide there. Dave kind of hit on some of the high points and talked about the Juul case a little bit. And the reason for that, as he mentioned, a couple reasons. Number one, hopefully at least some of the members of the board, I'm not sure about the timing for when, some of the information came in when it was voted to join the Juul litigation and all of that. But, hopefully people are familiar with that. We'll start talking a little bit about the Juul litigation, because it is a similar, it's very different topics, but it's a similar theory, a similar legal theory. So we'll talk about that a little bit. So just as background, again, the Juul Labs litigation, there was the settlement in December 22, and that was with Juul and some individual defendants associated with Juul, some board members and the founders of the company. And then, as Dave mentioned, we actually were in trial in April and May of this year in San Francisco. And during the middle of that trial, after we rested our case, settled with Altria. So a little bit of a preview also, excuse me, a little bit of a preview also. I presume that there were discussions. I wasn't involved with those with your school board there, but there will be, follow-up discussions again about the Altria settlement. And in addition to what Dave mentioned regarding the recovery from the Juul settlement, there will be, about a third of that again for the Altria settlement. So that's kind of coming down the road here rather soon. I would suspect in the next month or so, when the paperwork is kind of put together there. So let's move to the third slide here. Just a little bit of background, and I really appreciate Dave said a lot of nice things about our law firm. I happen to agree with a lot of that, and I obviously am biased. But as far as I'm aware, our firm conceived of the idea of suing Juul and Altria on behalf of school districts here in the United States, and we were the first law firm to do so. Other law firms jumped on board, and we kind of pioneered, that approach and the legal theories to get there. Our firm represented the largest coalition of school districts, large school districts in the United States, had the largest collective recovery for school districts, and our firm represented all four of the bellwether school districts, which was San Francisco Unified, Palm Beach in Florida, Tucson in Arizona, and Goddard schools in Kansas. So various different sizes and geographies there. As Dave mentioned, the San Francisco Unified case was the only one to go to trial in the entire litigation. And as he mentioned, Juul settled right before trial in the fall, and Altria settled in the middle of trial here in May. So we, our firm, myself included, we're all involved in throughout the case with the bellwethers, in trial preparation and in trial. We're the lead trial attorneys. Tom Carmel was the lead attorney on behalf of San Francisco Unified in that case. So, what does that have to do with social media? I would just say that our firm has kind of an unmatched record of taking on, some of these bigger affluent companies in complex cases on behalf of school districts. So if we go to the next slide there, again, just a handful of school districts that we represented, and this happens to be some of the larger school districts. I think it says here that the estimated gross recovery for the school districts that we represented was about $355 million. We also represented, school districts down in the, way smaller than I think the smallest one here is 80,000. I mean, there were school districts we represented with several hundred students. So just all sizes and types. The next slide number 5. And this was something that Dave alluded to. And so very much like with the vaping epidemic that was declared by the federal government, we've got the Surgeon General again, and this is just a couple months ago, issuing an advisory about social media and youth mental health. The Surgeon General recognized the mounting evidence of the risk of harm to children and adolescents from social media use. It's not just the obscene or inappropriate harmful content there, but it's the algorithms that are intended to maximize engagement. It's if you've ever seen, probably some of you may be on social media, but if you've ever seen in particular adolescents or teens, it's the endless scrolling, the feed never stops. The algorithms continue to provide similar types of content to users that's intended to maximize the engagement and to keep their eyeballs on the screen. And in that way, the social media companies are able to sell advertising, since signing up for the platforms and using the platforms is itself free. I think like 98% of the revenues that these companies, the social media platforms, those companies get comes from advertising. So, they're incentivized to keep children, adolescents, youth glued to their screens. Let's go to slide 6, please. Again, Surgeon General, I won't belabor the point. You all have the slide deck there. But, again, profound risk of harm. The Surgeon General makes the point that there are safety standards for other products in all industries, essentially. And it's time to take a look at tech companies and social media platforms and hold them to some of the same standards. Let's go to the next slide, please, which deals with some of the symptoms of social media.
Mike, can you hear me?
I can, yes.
Okay. I'm just, I think it'd be good if you move as quickly as you can, just because the board's got a number of other things to consider tonight. So move as quickly as you can, please.
Very good. Will do. I apologize if I'm taking too long. I'll buzz through this here. The point here, symptoms of social media addiction, what we've seen and what's been found is that the addiction to social media looks much like any other substance use disorder. Consequences are similar. That's slide number 8 there. And then what ends up happening, especially as it relates to students, as it relates to youth, is that the schools end up having to deal with these issues. So let's go to slide 10, which talks a little bit about the impact on schools. And again, frankly, a lot of these same impacts on the schools, the disruption, the distraction, diversion of resources, the need for improved education on some of these matters, all of that, which was kind of similar to the vaping, is still kind of, it's a similar need when it comes to social media and dealing with some of the addictions that the students are facing. The next slide just kind of points out, again, as Dave mentioned, the litigation is consolidated in California. There's a federal court and a state court proceeding that are proceeding in parallel, and our firm has leadership on those. The next slide, slide number 12, talks a little about the defendants. The defendants being Meta, which owns Facebook and Instagram, Snapchat, TikTok, Google, kind of a who's who of the social media platforms that students and youth are using these days. The next slide talks a little bit about, this slide number 13, talks about the public nuisance litigation model for social media. Again, very similar theory to the vaping lawsuit. Attorney leadership is the next slide, number 14. And so again, we've got a host of Wagstaff and Cartmel and other law firms, attorneys on that list of leadership. And those are all firms, Beasley Allen and Goza Honnold, firms that we work with regularly. So they're all kind of part of our group that works on these. The next slide, number 15, details of school district representation. Again, we can tout our expertise, but the other part of that is the cost to the school district would be just like with the vaping lawsuit, which is that there is no cost to the school district other than the time that you all are giving us here today, and a little bit of time to fill out, to review a complaint and fill out a couple of forms, and that should be it, unless the school district is chosen as bellwether, and we could talk about that if it comes to that. The next slide gives kind of just a bit of a recitation of some of the schools who have signed up for the litigation, schools fighting back. Again, this is just a small list, all different sizes of school districts that are doing, that have joined in the litigation. And I think at this point there are about 150 to 200 school districts involved. The last slide is contact information. So if you all need to get a hold of us, hopefully you got that and you're able to do that. If there are questions that come up, some other time other than tonight or in the future, we're always happy to field those and to hear from you all. So I think that's the fastest I've done this presentation. I appreciate you all bearing with me. And I will turn it over to Dave and everybody else for questions or, however you all want to proceed.
Any questions from board members?
I have a couple. I'm just curious. Actually, it's a twofold question. What has Jewel done since the lawsuit other than pay a bunch of money? What practices have they changed?
Good question. And Mike, did you hear the question? What, other than paying damages in settlement, has Jewel changed its approach in its advertising or whatever?
Right, so Jewel has had to stop its advertising, and part of that is complying with the Master Tobacco Settlement Agreement and the laws which have kind of made that apply also to vaping companies. So they've had to reduce or stop altogether all of the advertising, similar to a tobacco company, which is essentially what it is. In addition to that, and probably more importantly as it relates to Jewel, is that the company is essentially fighting for its life at this point. And so, I am not sure whether it's going to survive, and Jewel has not, to this point, received authority from the federal government to continue selling its product, but you will see it in stores right now while that decision is under appeal. So I don't know that Jewel has done anything to change the government's mind yet. I haven't seen the amended application, but they're kind of in the process of revamping their entire approach and trying to get approval from the government to continue to sell their products in the future.
Thank you.
If I could just quickly conclude by emphasizing a couple of things. One is, of course, it is fairly unusual for a school district to be a party plaintiff in a lawsuit. You're usually the defendant. But this is an opportunity to, aside from what monetary relief you may receive down the road, This is a very worthwhile cause, in my opinion, for a school district to be involved as a moving party, trying to bring about changes and hopefully to receive some sort of monetary compensation for the additional cost, direct and indirect, that I'm sure you've experienced as a result of the social media, quote, addiction problem. The other point is, again, as a plaintiff in a contingent fee case, there's no upfront cost to you, a monetary cost, either in attorney's fees or litigation-related costs. If the suit is successful, the attorneys, the firms, will receive a fee from the gross recovery, just as will be the case in Jewel. You got $150,000 in a gross recovery. That will be reduced by the attorney's fee and some litigation costs, but there will still be a substantial amount of money that will be available for you to address the fallout of the vaping issue. The same would be true in this case. I've been involved. There's one document that you would likely have to complete, which is called a plaintiff fact sheet, where you answer some questions about your particular district, the number of students, the number of schools, etc. I assisted several districts it took maybe 3 or 4 hours working with some district administrators to put together that plaintiff fact sheet. That's really the only time commitment that's involved. So as I see it, there's really no downside to being involved in, again, what I think is a very worthwhile effort and cause to hopefully bring about some changes. And I know that you're not making that decision tonight, but at least now you have additional information upon which to consider whether or not you want to join, as other South Carolina and other school districts throughout the country are now doing.
Go ahead.
If I may, I just want to state that this information is very interesting, considering the fact that mental health issues are extremely complex and involve so many layers. You know, one of the key questions we always ask is why? What's the cause? You know, what's the meaning behind these issues? So it's good to know, number one, that you've identified a predominant cause and that this is a way to attack it. And if this lawsuit can help or can force these social media companies to take different steps, because I think, you may have said, or I know we read it, that these social media companies, they know what they're doing. They know that the algorithms they've put in place are addictive. They've done that on purpose in order to entice and engage children. I think they need to be held responsible. So I appreciate your efforts to bring this about.
Ms. Ford, is there any other thoughts coming from the board about proceeding with this at our next meeting?
Yeah. I had another question that I was just curious about. What are the total damages being sought? And secondly, how do the companies, if they're found, I guess the term is guilty?
Liable,
thank you. How do they split it? And lastly, are there, in addition to the monetary damages, are there specific things that they're being asked to change, specific like algorithms and so forth, as part of the lawsuit? Or do they settle and then they decide whether what they're going to do?
Okay, I'm going to again turn this over to Mike. If you heard the question, one is if there is a monetary settlement, how is it divided up among the defendants? Another question relates to again what what may they be forced to change in going forward in the social media platforms? What might they do to fix this problem?
Right, so a few things there, so I believe the first question was what type of monetary damages are being sought? And the answer to that is that it really, I think the Jewel case can be a guide frankly, to answer all of those questions, or about the monetary, what you're seeking, and then what might be paid. The monetary damages being sought, I think that's going to have to come from discovery, and I can tell you that we were involved in that with the bellwether school districts, and to assess the monetary impact on the school districts, what we did was there are a couple components to that. The first component is, what's the damage that's already occurred? And as you might imagine, that's a little bit difficult to parse out because, disruption in the classroom might mean that a teacher's time is taken up, and then an administrator, a counselor, and so you're talking about time, and it's something that when you try to put damages to that, it's difficult to do. Now, we have ways that we were able to do that for the one case that we had to do that for, which was San Francisco Unified School District, leading up to trial. That part is kind of the past damages, so to speak, and so that's something that we have to kind of work up depending on the impact of the school districts. But it's similar to Jewel in the disruption, diversion of resources, creating new educational materials, that type of thing. The other component of the damages is future. So how do we deal with this then, right? So for Jewel, what we did was we had people go out to every single school in the bellwether school districts and assess those schools and assess what would it take to eradicate vaping in this school. And it's not an easy problem to eradicate. It's not an easy problem to deal with. And social media is very similar. And so what we do is, and what we did in the Jewel litigation, is engage experts who are experts in school safety, climate, culture, technology, those types of things, and kind of put together a comprehensive plan to deal with. So what types of things could be done to combat social media addiction in schools? Well, there's social media companies, or otherwise we can put limits on the amount of time that students are able to use certain apps. You can they can change the algorithms so that for instance they're not endlessly being fed materials. There are different things at school, or that social media platforms could have done all along that they never did. Limit the hours, limit the hours that notifications can be sent, for instance. People receive notifications, so-and-so commented on your photo. Well, then they get on there and they're back onto it. Limited targeting to minors. They have all the demographic information about everybody who's using their platforms, and they're able to kind of parse out who can receive what and when. Limit the features and algorithms that are used by the minors. Require images by social media influencers to disclose if they've been enhanced, or disclose the source of those images. There are a lot of different ways that can be combated, and some of it is just going to have to be developed with experts who are working in the field.
And Mike, if I could point out even some obvious things like addressing the inadequate age verification measures. I mean, for certain social media, it can only go to children who are 13 years of age and over. Well, that's not protected at all right now, or very inadequately. And just generally insufficient parental controls on some of these social media platforms. So those are, aside from monetary relief, those are some of the features of these platforms that could be addressed as part of the relief.
Right. Okay. Good, thank you.
I believe one of the questions was who would pay, and that would depend, frankly, on proof, right? And there are different legal mechanisms for, joint and several liability. So one company could be on the hook for all of it, or they may be able to split it up depending on their kind of comparative fault through the whole problem. But that's one of the roads that we would cross, and hopefully we will cross as the litigation proceeds, is kind of parsing out who's responsible for what part of it.
Very good. Thank you very much.
Thank you very much.
Thank you for your time
Thank you.
and attention. We will, certainly can answer any questions that you might think of after this session, and we'll be prepared to help in any way we can.
Thank you, Mr. Cutler. Thank you, Mr. Duff.
Thanks, Mike.
Moving on, our next agenda item is board superintendent comments or requests. Any comments from the board?
I would just like to thank the Discipline Committee for a great job on improving that discipline policy. I think it's right on target.
Yep.
And thank you.
Only comment I would like to make is many teachers are back in their classroom getting ready for school. Our teachers come back. Our new teachers and employees come in next week. And the following week, after our next school board members, our kids come back. And just an encouragement to our board members during the first week of school, please try to get out into the schools and see what's going on. That is very motivational to be seen out in our schools. And Mr. Price.
Thank you, Mr. Chair. Good evening, ladies and gentlemen of the board. I'll keep my remarks brief tonight, as the past several weeks have been filled with professional development, training, and other sessions to prepare for the start of school on August 3rd. Our new employee orientation will be next week on July 26th at Georgetown High School, and all teachers will return on July 27th as we continue to prepare for a great school year. I'd like to give a special thank you to our facilities, maintenance, and custodial staff who have been working extra hard in a condensed summer to prepare for a successful launch. Thank you, Mr. Chair.
Thank you. Next thing on agenda is executive session for update on pending litigation, discussion of recommendation for administrative duty reassignment, and discussion of employee grievance, and recommendation for director of special services. Is there a motion that we go into executive session?
Make a motion.
Been moved and it's been seconded. All in favor, please say aye.
Aye.
We are now in executive session. Is there a motion that we come out of executive session?
So moved.
Okay, it's been moved, it's been seconded. All in favor, please say aye.
Aye.
All right, we are now out of executive session, and there is no action that we need to take from executive session. There is. There is.
Yes,
One.
there is.
Sorry. I've been too excited here.
You ready?
I'm ready.
I move that the board approves the recommendation of Superintendent Keith Price that Tabitha Strickland be hired as the Director of Special Services beginning July 24, 2023.
Is there a second?
So moved.
It's been moved, it's been seconded. Is there any discussion? All in favor, please say aye.
Aye.
All right. The motion has passed. Welcome, Ms. Tabitha Strickland. And now, since there's no other action to be taken, we are now adjourned. Thank you very much.
Go.